court decision resolves a specific dispute among specific parties at a specific time. What it does not do is end the debate. Within the legal system, lawyers and judges will criticize and defend the court's decisions, and in the larger political system, the correctness of a decision, whether it is Roe v. Wade or Citizens United v. Federal Election Commission, is always legitimate grounds for debate. I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court, nor do I deny that such decisions must be binding in any case upon the parties to a suit as to the object of that suit, while they are also entitled to very high respect and consideration in all parallel cases by all other departments of the government, Abraham Lincoln explained in his first inaugural address. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, in ordinary litigation between parties, in personal actions, the people will have ceased to be their own rulers, having, to that extent, practically resigned their government into the hands of that eminent tribunal. Criticism by candid citizens often has eventual effect. Years or even generations later, the court itself may re-examine its precedent and even overturn it. Third, many important parts of the Constitution are never tested in any court. The other two branches of government make decisions all the time, and not all of them can give rise to a lawsuit. As an example, consider the decision by President Barack Obama to allow U.S. aircraft to participate in the NATO intervention in the 2011 Libyan civil war. Many people, including me, believed that the Constitution required him to get congressional approval. Obama, on the advice of some of his executive branch lawyers, chose not to do so. A group of members of the House brought a federal lawsuit against the president and were unceremoniously tossed out of court. War and peace is just one of the great constitutional questions that courts don't usually touch. In 1998, the House of Representatives impeached President Bill Clinton and brought him to trial in the Senate on the charge of having lied in a deposition about his affair with the intern Monica Lewinsky. Many people, including me, believed that a president's sexual behavior and his efforts in a private lawsuit to cover it up simply did not match the standard of high crimes and misdemeanors the Constitution sets for impeachment of a federal official. But no one was foolish enough to ask a court to stop the impeachment. Article 1, Section 2, Clause 6 of the Constitution gives to the House the sole power of impeachment. A court involving itself in the case would be wandering far off its Article 3 reservation. Again, the grounds of impeachment is a great constitutional question that will always be outside court's jurisdiction. In deciding whether Obama violated the Constitution in Libya, or the House violated the Constitution in impeaching Clinton, then we are on our own and must rely on the Constitution itself. But the quest for the meaning of the Constitution is not limited to lawyers. Citizens seek it as well. To them, the secret code is not what the courts have said, but what the framers intended. The words on the parchment, to many Americans, are much less important than what the framers were thinking when they said them. If we knew these secret thoughts, they would answer all our questions. So persistent is this popular belief that best-selling novelist William Martin recently wrote a book entitled The Lost Constitution, a Dan Brown-style thriller about the quest for a copy of the Constitution, annotated by the Founding Fathers, that can answer all of our current constitutional riddles. If we could just get our hands on some other words the Founders wrote, they would tell us the meaning of the words we already have. The Constitution, as Doctorow noted, is not light reading. The drafters of the Napoleonic Code intended their handiwork to be a central document of French identity, to be read before every Gallic hearth. The framers of our Constitution had less lofty ambitions. Unlike the drafters of the Code, the framers were not academics concerned with consistency and elegance. There was one exception. America's first law professor, George Wythe of Virginia, was a delegate to Philadelphia, but Wythe left the convention only 10 days after it convened, called home to tend to his sick wife, and never returned. His signature does not appear on the Constitution. They were practical men of affairs. Contrary to popular belief, only about half were actually lawyers. Most lacked the talent or